Hello everyone, my name is Sharon and today I'll be discussing section 35 of the Transfer of Property Act 1882, which deals with doctrine of election. Election basically means choosing between two inconsistent or alternative rights. Three parties are involved for election. A is the transferor who professes to transfer the property not his own. Second, the owner. Owner is the person to whom the property actually belongs and who is put to election. Transferee is the one to whom the property would be transferred if the owner of the property chooses to sell out the property. Doctrine of election is based on the principle of equity followed in England by English courts. Further, owner's interest can be contingent, vested, or remote. Here is an illustration to understand the concept of doctrine of election. A. The transferor professes to transfer property P which belongs to B to C. B is the owner of the property and A confers that he would pay 10,000 rupees to B if he transfers the property to C. Here B is put to election. He has two alternatives, either to accept the benefits and give away the property or reject the benefit and keep the property. Moving on to essentials or provisions in respect to doctrine of election. There are basically three essentials. The first essential is transferor professes to transfer property not his own. He just professes to transfer the property. He is not the real owner of the property and therefore cannot transfer property but can only make an arrangement or contract for transfer of the property. Transferor need not specify in words that he is professing to transfer a property not his own. It is inferred by the court from the language of the instrument. Further, knowledge of the fact that transferor has no authority to transfer the property is immaterial for application of the rule of election. The second essential is benefit should be conferred to the owner of the property. In lieu of the transferor confers certain benefit upon the owner of the property as he is put to election, so he must be given with some benefits. But we have to keep in mind that benefit must be given directly to the owner of the property. Indirect benefit would not amount to doctrine of election. Here is an illustration to understand this. A. The transferor confers a benefit of 5,000 rupees to B's wife on the condition that B transfers his property to C. Here, as there is no direct benefit given to B, so B has no duty to elect. He can elect both options in his favor. That is, he can keep his wife can keep 5,000 rupees and he is not bound to transfer the property to C. The third essential is part of the same transaction. Transfer of property and conferring of benefits should form part of same transaction. Further, benefits and transfer must be interdependent and inseparable. However, it is not necessary that the two transactions are provided in one instrument. Moreover, duty to elect arises only when person acts in one and same capacity. For example, if a person acts in two different capacity, for example, one as the owner of the property and secondly as the guardian or trustee, here there is no election as he is acting in two different capacities. Mode of election can be both expressed and implied. The mode of election is expressed when the owner expresses his intention in clear and specific words. In this case, the election is final and conclusive. The mode of election is implied when the intention of the owner is inferred from his act or conduct. In two conditions, we can presume that the owner has knowingly accepted the benefits. The first is he enjoys the benefit for 2 years without doing any act of refusal. Secondly, he exhausts or consumes the benefits. For example, A transfers to B an estate owned by C, and as a part of the same transaction, gives to C a coal mine. C does not elects in express words, but takes possession of the coal mine and exhausts it. It is here presumed that he has elected to take the benefits in this case. Requisition to elect is a special provision when the owner has not made a decision even after the expiry of 1 year. The transferee requires owner to make a decision. If he does not elect within a reasonable time after such requisition, he is deemed to have elected in favor of the transfer. The next concept is suspension of election. If owner is legally disabled, for example, he is a minor or a lunatic at the time of transfer, then the election is postponed till such disability ceases, or the election is made by the competent authority on his behalf, for example, by the legal guardian. Disappointed transferee is the transferee in case where the owner elects not to transfer the property, as this transferee was hoping of getting the property. The rights of disappointed transferee in case of gratuitous transfer and non-gratuitous transfer varies. If it was without consideration, that is gratuitous transfer, the disappointed transferee gets reasonable compensation when the transferor dies or becomes incapable of making fresh contracts. But in case of non-gratuitous transfer, that is with consideration, the disappointed transferee gets reasonable compensation irrespective of whether the transferor is dead or alive, from the transferor or from his legal representation. Further, it must be noted that the reasonable compensation in such cases is equivalent to the value of property professed to be transferred. Under English law, the owner can elect not to transfer the property and at the same time can keep the benefits arising out of the instrument. In this situation, the owner is known as refractory owner, and in this case, the owner has to compensate the disappointed transferee, and the duty of compensating the disappointed transferee is not on the transferor. Here is an illustration to understand the English law. A, the transferor, confers to pay 10,000 rupees to B, the owner, if he transfers the property P to C. The value of the property is 8,000 rupees. If B elects not to transfer the property, under Indian law, the burden of compensating the C, the disappointed transferee, is upon A. But under English law, it is stated that the owner can keep 10,000 rupees as well as can elect not to transfer the property. But in such case, the owner has to compensate the disappointed transferee, and therefore he has to pay 8,000 rupees to C.